Good. Good evening, everyone. If I could just have your attention. First, welcome. It's so lovely to see all of you here, particularly on a rainy January evening. It's great to have a good crowd out, so thanks for coming. I want to start off, as we always do, with the all-important land acknowledgement for us. So Dalhousie and the Schulich School of Law, of course, operates in the unceded territories of the Mi'kmaq, Wolastoqey, and Beskotumakati peoples. These sovereign nations hold inherent rights as the original peoples of these lands, and we each of us carry collective obligations under the peace and friendship treaties. Section 35 of the Constitution Act recognizes and affirms Aboriginal and treaty rights in Canada. We also recognize that African Nova Scotians are a distinct people whose histories, legacies, and contributions have enriched that part of Mi'kma'ki known as Nova Scotia for over 400 years. So with that, welcome again to all of you. I'm delighted to start us off tonight with a few words about the lecture series itself and the person who it is named after. Douglas Millard Johnston, after the namesake of the lecture series, lived from 1931 to 2006. He was born and educated first in Scotland, then completed graduate degrees at McGill and Yale, my alma maters, I have to say, where he studied with Myers McDougall and Harold Laswell and developed a lifelong affinity with the policy science approach to international law. In 1972, the ocean beckoned him, and Johnston and his family moved to Halifax, where he took up a position with the law school at Dalhousie. Over the next 15 years, Johnston was central to launching the law school's doctoral program and the development of the marine and environmental law program. At the same time, he provided advisory and consultative services to, amongst others, the Government of Canada and the IUCN, and co-founded and directed both the multidisciplinary Dalhousie Ocean Studies Program and the Southeast Asian Program in Ocean Law, Policy, and Management, centered in Bangkok. In addition, he published groundbreaking scholarly works on the regulation of international fisheries, the theory of ocean boundary, treaty law, and the history of international law. His last book, The Historical Foundations of World Order, The Tower and the Arena, was the title, was completed very shortly before he died and received a posthumous award for preeminent contribution to creative scholarship from the American Society of International Law in 2009. He has been described as a modest man who was very generous to students and colleagues, with an inspiring personality and a sharp theoretical mind, who profoundly influenced the future careers of many of his students. The first Douglas M. Johnston lecture was held in 2009. Speakers for this are selected for their demonstrated leadership in the field of public policy and their interest in promoting social and environmental justice. Elisa Morgera is a perfect fit, and I look forward to her comments. And with that, I'll turn it over to Sarah Seth, the director of our MILA program, and she'll say a few more words about Elisa. Thank you.
Thank you. Thank you very much. First, to Dean Sarah Harding, we're always really grateful for your support and that you tend to always come out to these events, and we're really, really happy about that. So thank you.
I'm a big fan.
Yay, it's wonderful. So I am particularly delighted to introduce our guest this evening. Professor Elisa Morgera is a professor of international law and sustainability at Durham University in the UK. She's also an adjunct professor in international and European Union environmental law at the University of Eastern Finland. And previously, she worked with the UN Food and Agricultural Organization in Italy and with the UN Development Program in Barbados. She's continued to collaborate with the United Nations and other international organizations as a consultant and independent expert for many years. She has advised governments and civil society in Africa, Asia, Europe, Latin America, the Caribbean, and the South Pacific. And Professor Morgera has also published extensively on human rights in the environment, the human right to science, as well as the human rights of small-scale fishers, indigenous people, and children, at the climate biodiversity and also the climate-ocean nexus. And she has also published a lot on the business responsibility to respect human rights. And I say this and show this book that I became quite familiar with as an early professor, because this is the book that Elisa published on international environmental law and corporate accountability with Oxford University Press, which dates from 2009. And I've been a huge fan of her work in the corporate accountability and international environmental law field for a very long time. And so it was with particular excitement that I noticed after I had moved here to Dalhousie and was starting to think about the oceans, that Professor Morgera started directing what's known as the One Ocean Hub, which was a global north-south research collaboration on human rights and the ocean. And this connected natural and social scientists, legal experts, artists, human rights holders, and defenders with the aim of supporting fair, inclusive, and transformative decision-making. And in addition to all of these wonderful achievements, she currently holds the position of the Special Rapporteur on Human Rights and Climate Change with the United Nations. And so with that, I would like to very much welcome Elisa for the talk titled Lived Experiences in Climate Justice, Reframing Priorities. Welcome.
Thank you so much. Thank you so much, Sarah and Dean, for such a warm welcome. It's really a pleasure to be here and have the opportunity to share with you not only the research and scholarship I've been involved for a few decades now, but also many of the things I've learned as UN Special Rapporteur on Climate Change and Human Rights over the last year and a half, really a momentous time to be reflecting on the role of international law in supporting climate justice, but also the role of our engagement with multiple knowledge systems and in particular lived experiences to understand where certain dominant interpretations and applications of international law are actually not working in support of climate justice. So I will start with a short reflection on how the recent advisory opinions of three international tribunals have clarified states' international obligations on climate change and have confirmed the relevance of international human rights law in the context of climate action. And that's interesting both because international human rights law clarifies with much more detail the scope and the legally binding nature of the obligations of states, which tend to be framed in open-ended ways under international environmental law and particularly international climate change law. But also because all three tribunals have confirmed something that maybe to many of us should have been already obvious and central to climate action, but in fact to this day remains very much a marginal consideration. And that is that the role of the protection of nature and the ocean and action against desertification are part and parcel of what effective climate action should be, and that international biodiversity law, the law of the sea, and the international law on desertification are also applicable to climate action. And that, to me, is in fact a precondition for ensuring the protection of human rights in the context of climate change and ensuring the adoption of also human rights-based climate measures. Because every time we see, and unfortunately we have a significant body of evidence showing that certain climate response measures that have overlooked negative impacts on biodiversity, on the ocean, or on land have led inevitably also to human rights harm. But then I will go on to show how would we understand the conjunct reading of all these areas of international law they have evolved in isolation. Their underlying bodies of science are still developed by different communities of practice. And while we have more and more connections, I think there's still work to do to fully understand what that integrated understanding, interpretation, and application of international law is, and how it needs to then change the current direction of travel in terms of climate action, nationally and internationally. And what I've discovered, and this will be the core of my reflection that I'd like to share with you, is how engagement with the lived experiences of those who have been most affected by climate change, understanding how that experience, often compounding with other experiences of marginalization, of racial discriminations, and other forms of vulnerability, also provides a distinctive understanding and, in fact, distinctive insights into why our current efforts are not sufficient to really protect us from climate change and advance mitigation or adaptation of climate change. And crucially, why we need to look at a deeper level and maybe not stop at the recognition of certain trade-offs, which is usually where in our scientific efforts we kind of stop and think, well, now it's a question of deciding who wins and who loses, and rather say, well, if there is a trade-off here, it means we haven't looked deep enough to understand what's really at stake, the root causes, and through that understanding then identifies the ways in which we can take action that can contribute to the realization of multiple separate and yet all relevant objectives of international law. And so really realizing both climate objective, but also the protection of biodiversity, of land, of the ocean, and all our human rights that are dependent on these elements of a healthy environment. And crucially, what I've been witnessing in this engagement with human rights defenders and human rights holders and organizations working with them in every region of the world is how their own individual experiences of injustices provide an understanding both of very local links between the environmental challenges and human rights challenges, and they're linked to economic inequality. And through that understanding, they provide, in a way, through a prism, an understanding of the systemic change we need and the change that needs to happen at all other scales, and that we find much more difficult to identify and grapple in the abstract and more siloed spaces, be that science and legal analysis and diplomacy, where these issues have been addressed in separate bodies of international law. And I will use two examples on which I've worked last year, looking at fossil fuels and critical minerals. And finally, depending on how I do with time, I will also share a few ideas about whether this understanding of the relevance of lived experiences as a central element of the integrated evidence base that decision makers need to be able to fulfill that understanding of integrated interpretation and application of international law, how that centering and recognition of lived experiences in the evidence base calls for important reforms of our decision-making systems, be that at the national level or internationally. So just very briefly, I'm sure there's many experts in the room who are very familiar with the advisory opinions. I will focus mainly from the more recent advisory opinion on state obligations on climate change of the International Court of Justice. As there are a few students in the room, I think it bears to remind that this was a student initiative at the very beginning. It was the Pacific Island students fighting for climate change who developed this idea and were then joined by a student movement across the world, eventually being first of all heard by the government of Vanuatu, and then creating a movement that was supported by all Pacific Island states, and eventually leading to a consensus resolution at the UN General Assembly, where all states represented there agreed to ask to the International Court of Justice to clarify states' obligations on climate change. And I think that in itself, it's an extraordinary process of social mobilization, of youth leadership, and of demanding from our international structures for, I think, a process of truth-seeking and of taking responsibility and playing a significant role when international law is not being used in ways that are really truthful and meaningful to the protection of our human rights. So many thought that that advisory opinion was quite a uncertain bet. The ICJ has been historically quite conservative in its jurisprudence on the environment in particular. And yet the whole process with written submissions and oral hearings has been also extraordinary. The highest level of participation that we've ever witnessed. Many states that had never been active before the ICJ decided to participate in the process. If you have not watched the recordings of the oral hearings, I really recommend watching them. There's several moments of goosebumps and really very much looking at how states, but also in some cases we had young people and others who were able to take the floor and really ask the court, how do we implement, how do we interpret international law in a way that really advances climate justice, that really meets the demands of those who have been most affected by climate change, in some cases for over a decade. And the response of the International Court of Justice has been extraordinary. I think has gone beyond the expectations of most experts, even if in and of itself the findings, I think, are not surprising. They don't go beyond our settled international law, very settled practices in terms of interpreting international law. But what is, I guess, striking in this advisory opinion, and it's really calling for an interpretation of international law that is very different from the dominant reading of international law within the international climate process and what we may be familiar in terms of the development of national climate law and action at the national level, particularly by high-emitting and historically high-emitting states. So for one thing, the ICJ clarified extensively and unequivocally that international human rights law are relevant and applicable to climate action and that are part of a body of stringent due diligence obligations that states have to protect the climate system and the environment. And the violations of those obligations entails state responsibility to provide reparations for harm. The ICJ, I think, discussed extensively which human rights have already been negatively impacted by climate change, including our right to life, to health, to adequate standards of living, our right to be protected from arbitrary displacement, protection of our private life, and the human right to a healthy environment, which you may know still remain to some extent debated by some states, but has found, again, recognition by the UN General Assembly following decades of relevant interpretative developments from the UN level to regional and national level. And in fact, the ICJ also clarified that the protection of the human right to a healthy environment is a precondition, it's inherent, and it's essential for the enjoyment of all other human rights. The court also paid attention to the disproportionate impacts of climate change on human rights, calling attention to the protection of the rights of children, indigenous peoples, rural communities, women, migrants, persons with disabilities, and other persons in vulnerable situations. And in fact, this understanding of the disproportionate human rights impacts of climate change is a critical area where an advancement of the understanding of the lived experiences and then their relevance for understanding how international human rights law then applies to climate action has really been, I think, one of the major contributions of the UN and regional human rights systems, particularly in the last 5 years. In fact, even in the last 3 years, there's been an incredible detailed understanding of how specifically children, specifically girls, specifically persons with disabilities, and so many others, what have been not only the distinctive and disproportionate impacts of climate change on them, but also the repeated and sometimes systemic blind spots in our climate responses that have not prevented those discriminatory impacts from being experienced by them. And again, crucially, what I did in my first report as UN Special Rapporteur was synthesizing all the work that so many other UN experts who I don't think expected to be dealing with climate change in dealing with human trafficking in dealing with gender-based violence, in dealing with human slavery. And yet they did, because of those impacts that were experienced by certain individuals and communities and groups, and that came up in their work and in their engagement with their lived experiences. But I think what's really interesting in that work is that it also led to a very fine-grained understanding of how our climate measures, including early warning, including responses, including mitigation, can be so much more effective and fair if they fully take into account what we have learned and what the persons who have been most affected by negative impacts can offer in terms of insights of what needs to be improved and what mistakes needs not to be repeated. As I mentioned at the start, the ICJ, but this is also the case of the other two international tribunals, have stressed the importance of the applicability also of international biodiversity law, the law of the sea, and international law against desertification in the context of climate change. And one particular point that I think is really interesting and has come up from all three advisory opinions is the importance of protecting and restoring ecosystems as a form both of climate mitigation and adaptation, in fact, as the ICJ said, as a form of reparation for climate harm. And what is emerging from the work of other UN Special Rapporteurs, particularly the UN Special Rapporteur on the right to health, is that in fact when you engage in ecosystem restoration and that process of reestablishing human connections with nature and coming to terms also with historical and systemic reasons why certain individuals were more exposed to climate harm, this is a process where we're able to support individual and collective healing and intergenerational alliances. So really interesting understanding coming from that connections, not only of the integrated reading of international law, but also again the lived experience of what happens if we apply international law in such an integrated way, and what that means for human well-being and for human and planetary health. Interestingly enough, the ICJ went further than all other advisory opinions, also in clarifying the legal consequences that arise from states failing to prevent significant harm to the climate system and therefore not complying with their applicable international obligations. And these legal consequences then include revoking all administrative, legislative, and other measures that constitute an internationally wrongful act. And then the court clarified, I think to the surprise of many, that fossil fuel exploration, production, consumption, and subsidies may all and each in their own terms constitute an internationally wrongful act. So what was interesting for me is, first of all, to see this very explicit indication that, of course, climate science is unequivocal, that fossil fuels are the main cause of climate change. But in fact, in my own work as Special Rapporteur, I've also looked at how international biodiversity science is showing us the harm that fossil fuels cause to human well-being and to nature, and how that then plays out in relation to both the capacity of nature to regulate the climate and human capacity for resilience. And then what the lived experiences of those, the frontline communities who have faced what are now intergenerational negative impacts of fossil fuels harm on their lives, on their health, on their food systems, what that tells us about how can we move away from such a system and what it means in terms of protection of human rights and advancement of the human right to a healthy environment, not only for these communities, but in fact the protection of everyone's human right to a healthy environment. And so again, that idea that from a very specific contextualized lived experience, we are able to understand a systemic change and how that can have repercussions in multiple scales, including for the well-being of individual and communities that can be at a distance and may consider themselves to be at a safe distance from the harm caused either directly by fossil fuels or by climate change caused by fossil fuels. I just want to add very quickly that it's still relevant to read the Inter-American Court of Human Rights advisory opinion on climate change, because of course that provides much more level of detail on what it means to apply human rights in the context of climate action. And in particular, what the core did is, first of all, I think it's extremely vibrant in explaining how that understanding that maybe in the ICJ advisory opinion is quite clinical, let's say, about which areas of international law apply. What the Inter-American Court does is really clarifying that that legal understanding means protecting all the life-supporting systems on our planet. That we can't look at climate change in isolation from all the other interlinked and interdependent systems that make life possible on this planet. And each and every of these elements that are so interlinked with one another has implications for all the dimensions of our human well-being that are protected by human rights. But crucially, that through the human rights lens, again, we do see potentially more clearly than otherwise at the root economic causes of climate change and of our current limited efforts to fight climate change effectively. And so really looking at the links between limited state action or delay or obstruction of climate action and how that is linked to economic inequality, and how all the forms in which the delay and obstruction, be that climate disinformation, be that growing attacks against environmental human rights defenders, be that even the adoption of ineffective or discriminatory climate measure, all these separate issues and separate human rights issues that we are facing in the context of climate change, they all boil down, they all have a common root in inequitable economic system. And this is why I think I want to discuss more how do we tackle that? I mean, it does feel like, first of all, something that's beyond the areas of expertise of many climate experts, or many environmental lawyers, or many law of the sea lawyers. And sometimes we even worry, well, is this even within the scope of these areas of law and our instruments that we have developed there? And this is where I think I want to demonstrate how that engagement with lived experiences really show how it's not just a legal abstraction that we need to look at all these areas of international law in an integrated way, but it's also a necessity, and a necessity that is reflected in how all these different areas of public policy, of international law, and of national law and separate bodies of administration becomes very much a very clear interconnection in the lived experiences of those facing and having facing the brunt of climate change and its impacts. So I'll move now to the first example, the area of fossil fuels. And just to say how interesting it is to see how different communities of experts and advocates are now really aligning around the need to phase out fossil fuels. This used to be a topic that was really led by certain areas of climate justice and climate and human rights movement, but it wasn't necessarily a very shared understanding for quite a long time. And now we're at a moment where already, for instance, work on children's human rights and the UN Committee on the Rights of the Child have clarified that phasing out of fossil fuel is a state obligation that's inherent to the protection of children's rights to a healthy environment. Also, I've been in awe, and I've been learning so much from all sectors of the medical profession across the world, and Canadian medical associations are very active in Belém at the Climate COP in November, to show how, from a medical perspective alone, we have so much evidence of how fossil fuels, throughout their life cycle, at the level of exploration, exploitation, transport, processing, and waste management, they all can affect every single organ of our body. On top of that, through the production of plastics and the production of petrochemicals, they also provide yet another layer of human rights harm directly through our food systems, and further layers of harm to nature, to water courses. And that means that the capacity, again, of natural processes to regulate the climate is yet affected and undermined by these other products of the broader fossil fuel economy. And our health as well suffers from that. So it's really interesting for me to also come to a conversation with the lived experiences of the medics, doctors who would have seen in their career and their profession how the harm from fossil fuels was materializing in their day-to-day work, how it was also in itself having discriminatory impacts on children and on women in particular, and all the different forms, really looking at the cumulative impacts from toxic pollution to air pollution, and then those impacts on damaged soils that would then no longer be able to provide for healthy foods, and again, and how all this harm would remain unaddressed. It wouldn't be covered by the fossil fuel companies themselves. Often it wouldn't be recognized, and communities would find themselves with not only living with the harm, often with intergenerational impacts, but also having to bear the costs, having to bear both the cost of their protection of their health and either living with the impacts of unattended and unremedied pollution. And so what is really interesting is that on the one hand, we have these lived experiences. On the other hand, I think on the aspect of like climate science and broader connections with also other areas of biodiversity science, we've come to an understanding that basically there's been a bit of a carbon tunnel vision, that we've been thinking about solving the climate problem through decarbonization, but in fact that is a way to somehow deflect attention from the fact that even if we completely decarbonized all activities related to fossil fuels, we would still have so much harm to the environment and the climate system and human health that would remain unaddressed. And all of this in itself would exacerbate the impacts of climate change and undermine our capacities for resilience. And so paradoxically, while we want to continue with the decarbonization, what this, I think, convergence of science and lived experiences is showing is that we need to also move to an understanding of how we still need to phase out fossil fuels to prevent all the other harm on top of the role of fossil fuels as the main cause of climate change. And this is really important because we find ourselves at a time where, as you may be very well aware, in fact, fossil fuel exploration and exploitation are in expansion, and they're in expansion targeting areas of higher biodiversity importance and fragility, deeper areas on the ocean where we don't yet have necessarily all the scientific evidence necessary to ensure other safe operations. And when we have growing and growing understanding of the role that biodiversity and the oceans play in climate regulation and in the protection of human health. So what was very interesting for me at that point is also engaging with a phenomenon that had already been addressed by other UN special rapporteurs. I wonder how many people in the room are familiar, but with the idea of sacrifice zones, that often we have seen how fossil fuel related operations and other particularly polluting activities would be all concentrated in areas where communities who were already disproportionately affected by poverty, marginalization, and racializations were based. And that would then lead them for them to face higher risks of chronic respiratory, cardiac, reproductive health, and other conditions. Now, this issue of sacrifice zones is global. We have sacrifice zones everywhere in the world. And I think, to me, what was interesting there was to hear the experiences of those who find themselves living in those areas or in the proximity, to see how these areas are basically completely abandoned by any form of regulation, any form of remediation. They're just an acceptance and somehow an idea that maybe if you concentrate all these harms in one area, everyone else is safe, and we're sacrificing some, but we're protecting everyone else. And of course, that is inaccurate. Very often sacrifice zones are paradoxically territories of life. Some of the areas where either they may be indigenous people's territories or other areas that are actually very important as sources of food, as sources of, or for the protection of water courses. And in all events, a lot of the pollution is not restrained to those areas. So there's an ancient fallacy in that understanding that sacrifice zones contain harm, even if they do very clearly disproportionately harm some human rights holders and are in and of themselves not acceptable. But what was interesting for me in thinking more and more and listening to those experiences is realizing that sacrifice zones are the iceberg tip of a logic of sacrifice that serves to justify a continued reliance on a fossil fuel-based economy. And that's when we go back to that idea of the trade-offs, that idea that maybe we can continue with an activity, but think that there may be somebody will be harmed, but others will be protected. And that logic is in, I think, inherent contradiction to that understanding from the advisory opinion and science that all our forms of life are interconnected and interdependent. That sea level rise not only affects coastal states, also affects mountain states, it affects glaciers, it affects the levels of salinity in our bodies, and therefore reproductive health, for instance. And so it's a logic that we see time and again, and somehow it's normalized to some extent. It may appear as at least favoring certain sectors of society, but it does obscure the scientific evidence that shows that all the harm that's produced to the environment and the climate system reaches far and beyond and has impacts on all of us. And this is where particularly thinking about those connections, which again, we tend to kind of leave on the side, well, if we're talking about climate change and decarbonization, we're thinking about maybe phasing out fossil fuels from the energy and transport sector, and then we're done, we're good. But in fact, fossil fuels are expanding. Why? Because they're trying to produce more plastics. Well, in effect, we're looking at plastics in separate international processes, but we are all painfully familiar with the fact that we're all affected by plastic pollutions everywhere in the world and all parts of our bodies and our food systems. And this is part of the same fossil fuel-based economy. And then we take the additional element of agrochemicals. And we don't even know all the toxic substances that are part of plastics or agrochemicals, and yet they are allowed to dominate our food systems. And we have indications of how that affects negatively our health and the possibilities of having nature as part of food systems, again, contributing to regulation of the climate and support for our human well-being. So in a way, it was again seeing how these things become alive in some people's reality, but it gives a signal to all of us to realize that trying to kind of narrow down the problem to what may seem in abstract, maybe a more manageable one for states to take action, is actually keeping us away from a real solution, because it's keeping us away from an understanding of the real deeper root cause. And for instance, one moment that for me was really quite game-changing was having conversations with environmental human rights defenders in Asia, and how they were telling me, well, our sacrifice zones are growing, and they're growing because not only we're producing more and more coal, but we're using coal-fired factories for treating plastics, for recycling plastics, and for recycling e-waste so that we can recycle critical minerals for renewable energy. And then you realize the complete fallacy of that model and how we're going in all the wrong direction, even in areas that on the surface of it are meant to be walking us away from fossil fuels. So I think that experience, of course, shows not only how even worse the situation of some human rights holder is in the context of growing sacrifice zones, but also how those sacrifice zones are hiding to the rest of us that the overall direction of travel is not the correct one, to really move us away from the root causes of not only climate change, but also the other planetary crises we're facing, which are that of biodiversity loss and toxic pollution. And to me, what was really interesting there was then understanding the economics of it. And I think I might not go into all the details of it. But once you see that there is a lead that arises from that engagement with the lived experiences that pushes you to say, well, okay, let me then connect all these dots and then go deeper. And that deeper understanding then is also reflected in understanding of the economics, and how the economics of the fossil fuel-based economy are an economics of sacrifice, an economics that is inherently going to expand that gap, the inequality, economic inequality gap, where we're still seeing the same companies who for decades knew that they were going to cause climate change and kept it away from the public, are still earning to this day some of the most exorbitant profits on this planet. On top of that, they're also heavily subsidized. And even if they're subsidized, we're still paying growing living costs for having access to a heavily polluting, climate-causing source of energy. And while our living standards are declining in terms of healthy food, our own health, and as well where our tax money is going, we're bearing the burden of our states choosing to use our tax money for subsidizing fossil fuel companies as opposed to using that money for the transition to renewables or any other measures of, for instance, adaptation to climate change. Again, just to give you an example of, in a way, one of the most absurd paradoxes. Most fossil fuel infrastructure is based, 30% of global refining capacity linked to fossil fuels is based in areas that are exposed to regular and increasing floods and sea level rise. Now, that in itself increases the risk of the populations having higher risks of health impacts because of more likely accidents and disruptions in those facilities. And that in turn will also have disruptions of their healthcare services during extreme weather events, and who will then pay the price of any property damage and displacement. And the cost even of the infrastructure repair or environmental remediation usually is taken up by public budgets as opposed to private companies' budget. There's much more that I could tell you about what I've learned, for instance, in relation to tax and illicit financial transactions related to fossil fuels and how all of that has impacts on taxpayers. But to me, it just shows how this area of evidence, which again is not often central to that understanding of what are all the reasons why fossil fuel phase out is essential. And in fact, continuing to produce or consume fossil fuels might be an internationally wrongful act. And some of the evidence, like this urgency that derives from the lived experiences of those most affected by climate science, by toxic pollution and biodiversity science, is reflected also in economic analysis. And so with that, I guess, just to give an example, what do I do with that knowledge? What was interesting for me were identifying two key priorities, which are not currently priorities in the international climate process, and often are not priorities or not enough in national climate action. One, saying that we can't just decarbonize. We need all our countries to defossilize our economies. And that means not just phasing out fossil fuels from the energy sector or the transport sector. We need to defossilize our food systems, which will be the topic of my next report, because the fossil fuel reliance, as well as those plastics and petrochemicals, they're not doing us any favors in terms of our own health, all our human rights dependent on healthy food, or worsening climate impacts. But also that we need to move away from an approach that's only focused on carbon dioxide, because there are many other impacts from the full life cycle of fossil fuels that are worsening climate change, as well as undermining nature and human capacities for resilience. But the second was also then really understanding there's something else. We need to move away from this focus on technological fixes of our current economic model. Because clearly, if you look at the root cause of what's causing economic inequality, then we need other economic models where we move away from that priority for private actors, where we really move into an understanding of how do we protect public budgets, and we use those public budgets for the protection of human rights and the protection of the needs of the most vulnerable, as opposed to prioritizing maybe the needs of the super rich, as has been very clearly documented, for instance, by some of Oxfam work, which leads in themselves to overproduction and overconsumption that keeps all of us in the context of multiple planetary crises. And again, we don't see that as being central to current conversations. Well, we have to revisit what does it mean that we are dependent on fossil fuels, and all our economies are built around that and are built around that logic of sacrifice. And how do we open up spaces to reimagine economies that would be fossil fuel free and lives that would be fossil fuel free? What would that mean for our health systems? What would it mean for our choices as individuals, as collectives? And that leads to that point around developing participatory processes where we can be able to fully explore this and bring together all these areas of understanding, and crucially, all of us being able to listen and learn from the human rights holders who are most affected by climate change. How much time do I have left?
Keep going for a bit longer.
Okay, maybe I'll take 5 more minutes just to make the connection with what are called energy transition minerals or critical minerals, because this is really, again, shows how the logic of sacrifice is still at play, even in areas where we see this is where we need to make progress, and we are making progress in climate mitigation and our transition towards renewable-based economies. So you may be aware that in all regions of the world, the extraction of critical minerals is very harming. We have multiple violations of human rights. We have significant harm to biodiversity, to soil quality, to water courses, partly because apparently with the excuse that this is an emergency and we need to rush to get those critical minerals to transition, we need to do away with usual environmental procedures. So most states have exempted or given a lighter approach to environmental planning and regulation and consultations for renewable projects and critical minerals. Now, this, again, doesn't do anyone any favors, because we need a process where we use all the available science which we have to make sure that those interventions are limited to the minimum, if any, harm on biodiversity, on water courses, and on human rights. And many of the human rights violations that have been documented time and again are very familiar. In fact, the worst kind of corporate practices in terms of human rights violations that we've known for a long time and that are perfectly preventable and foreseeable. And again, I mean, it really pained me when I started my work as special rapporteur to hear, again, from environmental human rights defenders around the world how harmful and how damaging that search for critical mineral was, while we are surrounded by indications that we need 6 times more critical minerals than we already have by 2040 to really respond to the demands for energy that we're facing. And so again, it felt like, well, is this again another gigantic trade-offs? And to what extent we're trying to limit environmental harm and potentially even human rights harm? Again, are we caught into that trade-off, if not logic of sacrifice, because this is something that we need? And that's where, again, the engagement with lived experiences and how particularly indigenous peoples on whose territories from 50 to 80% most of the critical minerals we need are located, but other communities too, how their experiences of injustices and violence were indicating that there was something deeply wrong about what we're currently doing in our search for critical minerals. And again, it wasn't necessarily a direct indication of what was wrong, but it was really giving I think, a lead about looking deeper. And that's where I think some of the research that's been also undertaken in usual research context came together, and it was really enlightening. So on the one hand, if you look at those projections of demand for critical minerals, there's several flaws in those projections that are never mentioned. I've been in so many events on critical minerals, including led by civil society and activists, where we all start from the viewpoint we need 6 times more critical minerals than we already have. We all take that as that's a fact of life, and that implies sacrifice. But in truth, if you look at those studies on demand projections, first of all, they never consider technological progress on recycling and resource efficiency. So that's already a huge issue. So we're all rushing to get how much minerals do we need? That's a question that comes from the communities affected. Well, for one thing, we can't trust those projections at face value because a critical element is missing. But then I think an even more critical, and that's again where the logic of sacrifice come to the surface, is that which sectors are behind the demand for critical minerals? most projections don't differentiate between the demand that's needed for the energy transition and other demand, the demand for militarization, the demand for more data centers, which again, the unlimited growth of data center has created so many concerns around energy use, water impact, as well as a myriad of human rights issues that we don't have the time to go into. But critically, that kind of shows that, wait a minute, so we're in theory prioritizing and cutting red tape for critical minerals because that supports our transition away from fossil fuels. But in fact, we're supporting sectors that are very heavily reliant, if not interconnected with the fossil fuel-based economy, such as militarization and to some extent, big tech. And then there was the final, I think, scent that kind of came into line, which was, and even within our efforts for climate mitigation, a lot of the critical minerals are needed for instance, electronic vehicles. What are these vehicles made of? Plastic. So even those vehicles, for let alone how much affordable they are and all the other issues, they're not taking us away from a fossil fuel-based economy. And so what all this kind of showed is that even here we have to go much deeper into only looking at what is truly changing the economic system and addressing and moving away any benefit, be the economic subsidy or any public decision relating to resources that is still supporting a fossil fuel-based economy and all the actors who are still benefiting enormously from that economy at the expense not only of those, but definitely certain human rights holders who are at the front line, but really all of us and all of our human right to a healthy environment, our right to health, all our human rights that depend on us moving away from those planetary crises. And so again, what's the priority there? Well, it's not figuring out how we're gonna mine in a more sustainable way. Of course, we have to look into that, but the real priority is whose energy and mineral demands are we prioritizing and whose energy and minerals demands are we leaving behind? And that's really the number one obligation, in my mind, for states, to really look at what is currently driving this deeply harmful activity, which does violate, in many cases, the obligation that states have to protect the environment and the climate system, as the ICJ said, and really looking at whether those decisions are sufficiently based on a moving away from the current economic system and not just under the surface, continuing to support the same economic actors and the same dynamics of overproduction and overconsumption and harm to the environment that inevitably harm our human rights. So I'll stop there.
Thank you very much for that. I'm going to give you a little gift, but we're also going to do some question and answer. So thank you so much. That was really fantastic and much appreciated. So, okay. Comments, questions? At the back. Love it.
Thank you so much for this lecture. It was really amazing. I have recently just been looking at polluter pays principle and the deterrent effect and linking that with the need for liberation. And this evidence you're giving about the effects of fossil fuels. So I was wondering if maybe while you were thinking about actions towards moving away from fossil fuel, did you at any point consider if high emitting countries paying reparations for all this would be one of those actions?
We're taking one by one?
Sure, we can
No,
start and then.
thanks so much. And I had a bit in my presentation ambitiously on reparations I didn't get to. Maybe two things at the start. So one is, interesting enough, the ICJ in its advisory opinion indicated that the polluter pays principle is not applicable, which I think was quite a surprise. And I think we need to do quite a lot of reflections with all the experts about what that means and why that is the case. What I have observed is that many advocates and all the experts working on climate justice, they all use the polluter pays as a rhetorical tool, and I think it sounds right. But to be honest, I've been hesitating to do it because I do think that the scholarly research on the application of the precautionary principle is actually showing that it's very often used to limit or to take very narrow and almost like exceptional approaches to when international law requires private actors to pay or states to pay. And so in a way, maybe there is a tension there with instead the broader recognition by the ICJ, the states who are in non-compliance with their stringent due diligence obligations not to harm the climate system should provide a whole range of remedies, including potentially financial compensation. And interestingly enough, one of the reasons why, for instance, states have not agreed in the context of the climate COP even to refer to the ICJ advisory opinion is because we have a very strong political opposition to even entertain the idea the states owe reparations for climate harm. Now, where do we go with that? What I have done in my own work is really looking at, first of all, the importance of the human right to effective remedy and what we've learned under human rights law about what that means. How do we provide effective remedies? And again, the practice under human rights law is to say, well, this needs to be victim-led process. We need to co-identify the remedies with those whose rights have been harmed, as opposed to imposing those on them. And the other thing that to me was really interesting, again, drawing on the lived experiences, is the experience, particularly in Cancer Alley in the US, where we had the start of a reparation process and what that has meant in terms of both environmental and sociocultural restoration and the possibility of discussing also historic and structural injustices. So in the context of that kind of more political debate about how do we get states to even discuss this, I think it's really important to use to rely on these lived experiences also to show how restorative, and again, how many benefits for broader society can arise from effective reparations for climate harm. And again, drawing again from those findings from the Special Rapporteur on Human Rights to a Healthy Environment to see how that really creates a space where we understand our relationships with nature and we find ways for healing and collective well-being as well as individual well-being and broader alliances. The other interesting aspect of this is, so there's financial compensation, and I think what I have been exploring in my report is really looking at, I think, an obligation of states to require the fossil fuel companies to pay. I mean, we're looking at decades of harm, and we're looking at decades of exorbitant profits, and we're looking at decades of subsidies, and we're looking at decades of loss of public income going into remedying and responding to the health harm and all other harm that climate change has caused already. There are several ways in which this can be done. Some experiences of, I think, climate super funds. Other ways to really, rather than say polluter pays, but just really use law to really attribute specific harm to those companies and have them bear the costs. And of course, planning in advance now, particularly when we're looking at the closing of infrastructure, to look at not only the very safe closing of operations and the looking after any residual harm that may be there, but a participatory planning with all potentially affected communities and other experts, maybe communities that have been affected in other areas can share their knowledge and develop a plan that can really be as aligned with our understanding of who's been harmed and how and what has been, all the costs that have been falling through the cracks. But importantly, I think another element is that it's not just about pain. The ICJ has indicated that all consequences of harm should be looked at. And that includes, for instance, what I was saying earlier, ecosystem restoration, other forms of guarantees of non-repetition. And in many ways, these are actually complying with primary obligations. States already have obligations to restore ecosystems. They already have other obligations that would work as guarantees of non-repetition, including phasing out fossil fuels as a form of climate mitigation. And I'm still kind of pondering about how this overlap between primary and secondary obligations, and how, there can be a way both to create more acceptability of this by states, but crucially for us as citizens, as taxpayers, to also kind of demand that reparation is not something that we owe to somebody else. Again, all of our well-being is intertwined with remedying to that climate harm wherever that's happening.
Thank you. Excellent first question. Second question? Okay, go there and then.
Thank you for your talk. You kept referring to lived experiences, which, I recently read a doctoral thesis which used lived experiences as a method to sort of, connect the author's, work with the law and interaction with international law. And so I just wondered if, and it's unusual to talk about lived experiences in the international law context. And so I wondered if you had any insights on lived experiences as an emerging method within international law scholarship, and whether there's any future to, exploring such a method.
First of all, it sounds like you're the best person to answer that question. I definitely look forward to reading your work on that. I think what I've done in my own scholarship before becoming rapporteur, and then that has taken a whole other dimension as rapporteur, has been looking at how transdisciplinarity, and so knowledge co-production across diverse knowledge systems, is essential for a integrated first, but then also genuinely helpful interpretation of international law. So the work that Sarah mentioned about the One Ocean Hub was really that experiment in saying, how do we bring together natural sciences, social sciences, arts, first of all, as a way to be able as researchers to engage with indigenous knowledge holders, small-scale fishers, other local holders, the distinctive knowledge that women in small-scale fishing communities have and in other contexts have, and really challenging ourselves to develop the research process and challenging one another to understand how each discipline will be helpful but also unhelpful in that process. And that was mainly at that point to understand when we are not fully bringing together the evidence we need to then be able to interpret and implement international environmental law, the law of the sea, and international human rights law together. I think since then that understanding has deepened, and I don't think I have fully worked out, but an understanding of how lived experiences of those most affected by climate change and other systemic injustices that make them most vulnerable to climate change gives us both leads into deepening that interdisciplinary analysis, but also gives us, I think, in a way, a moral obligation to really look at and accept as legitimate an interpretation of international law that is fully aligned with the point of contact between lived experiences and multiple bodies of science who all indicate that particular conduct is needed for us to fulfill those multiple international objectives.
Great. Let's go ahead.
Thank you so much for your presentation. I just wanted to ask a quick question that's an extension of the first question. So about reparations and attribution. So you make, and a lot of other states during the proceedings make very strong evidence-based arguments that phasing out fossil fuels should entail a primary obligation, especially under the customary rule of prevention. But I feel like the thorny issue lies in the state responsibility part. So production subsidies should constitute attributable conduct when establishing state responsibility, which may then trigger duties of reparation. But I find that in addition to what you said about the strong political opposition in COPs to phase out of fossil fuel, the ICJ in its own advisory opinion seems to very purposefully not mention, not characterize climate injury in terms of injury to the climate system. So they only exclusively focus on injury to states and individuals. So how do you think this would play out, for how easy it is to invoke duties of reparation in the future.
Yeah, so I'm not sure if I understand your point about the court not having clarified. Do you say it doesn't clarify what harm to the climate system look like?
No, for their answer to question beyond state responsibility, they only focused on climate harm to states and individuals instead of the climate system. So they excluded injury to the climate system. So that would bring up a lot of issues on establishing causation and attribution.
I mean, I think that, the advisory opinion did go very far, but it's not fully working out all the elements of state responsibility. Whether that is the case, I'm not sure, but I find that partly maybe the problem with that is that those areas of relevant and applicable law are discussed in separate chapters. And so you have the discussion of international biodiversity law separately from the discussion of international climate change law and the law of the sea. And that in itself, to me, is kind of missing the point about really explaining what protecting the climate system means and how that is intrinsic to also the protection of human rights. In a way, to me, it's clear in the Inter-American Court when we see that really that embracing of the notion of life-supporting systems. So that may be an explanation more on the kind of the geeky side of why that has happened that way. What it means then in terms of our own interpretation and how we move forward. I guess that in a way, maybe the court took a shortcut saying, well, we have some very clearly attributable conduct. That conduct, so the whole fossil fuel piece and attributable conduct there, that is harmful to states, it's harmful to individuals, it's harmful to the climate system. We don't need necessarily to kind of split air so much. It just kind of, in a way, it's almost saying it's very clear what attributable conduct we're looking at. And in the end, it's very clear, as you were saying, this is it's a primary obligation to phase out fossil fuels. And in my mind, it's also a secondary obligation. How can we have a guarantee of non-repetition if you're still expanding exploration, exploitation, and subsidizing of fossil fuels? The attribution, the kind of attribution science piece remains very underdeveloped in the advisory opinion, but that's where the science itself is advancing so much, and also I think legal innovation through litigation is, it's almost happening at, significant speed as the court was pondering these issues. And I guess we will see that in the future cases, be nationally or internationally potentially. But I personally don't see a lot of difficulty in, filling the gaps of the legal arguments. And bringing together the evidence. I think the really important thing to do is, whether we choose one or the other for litigation strategy purposes, to just keep in mind that interconnectedness, that, whether we're protecting states, we're also trying to protect people and the climate and life supporting systems, and making sure that in our legal reasoning and in the reliance on the science and knowledge systems, we try and be ourselves as interconnected in our thinking to avoid any potentially limitation in approach when we might be successful. Partial answer, I'm sorry.
Other questions?
Thank you so much for your lecture. It's fascinating. I think something that we're seeing right now is that there's an effort by the oil and gas sector to shift liability from private enterprise to public purse.
Can I ask you to speak up just a little bit, please?
There's an attempt to shift liability from essentially private enterprise onto the public purse. I know that in Canada we have extremely significant liabilities that are likely unfunded, and if we're to take the premise that Canada is responsible for these acts and needs to shut them down in a timely fashion, we'll likely have a lot of stranded assets and insufficient private funds to remediate harm to the environment here, let alone harm to the global climate. I was wondering if you had any views on the relationship between this likely happening and the human rights impacts on societies will ultimately have to pick up the tab when we initially thought that the polluter pay approach would fill that gap for us.
Yeah, I mean, I still think that companies have to shoulder the bill and that we have to learn all the lessons we can from how they have got away with it so far, because it's not new that they're having public budgets and our consumers shouldering the bill of all their negative impacts while they're still making exorbitant profits. And it's not a question of them not having the money either. I think what was really interesting for me, also thinking in the whole question of where is climate finance, there's no public finance available for climate finance, be that nationally or internationally. There's plenty of finance, it's just all going still in the same pockets, and none of that finance is coming out to really, for states to ensure the maximum available resources are devoted to the protection of human rights, and that's one of their obligations, and there are many regulatory ways in which they can achieve that. And equally, another interesting dimensions of international human rights law is that companies themselves have an international responsibility, which of course many do not like or practice, to protect us from climate harm, prevent being complicit in further climate harm, and all this aspect of the finance or claiming that they don't have finance is part of their responsibility to protect our human rights. But we have to kind of dismantle, a decade-long practice of all of us either not being aware or assuming that, that needs to remain some, all the harm and including the closing of fossil fuel operations and remediation needs to be our financial problem. Yeah.
Great. Other questions? Looking on this side. One more back here.
I was just wondering what you think the role of international organizations, like the responsibility, how that changes given the changing global context and the degradation of the international rules-based border liberty. Like, do you think that the ICJ, for example, has different responsibilities now that laws that they try and enforce are becoming less enforceable?
Okay, so maybe there's two questions there. So one is the role of international organizations, which I think is really interesting. And then there's the question of us finding ourselves in a situation where international rule of law and international institutions as we know them are in a deep existential crisis. So first of all, role of international organizations, I think actually not enough international legal research and advocacy has been done about clarifying the human rights obligations of different international organizations. I'm thinking of the UNFCCC Secretariat in the first instance, but also international financial institutions who still keep supporting activities that are harmful to the climate system or that support the fossil fuel-based economy. So there's a whole, I think, area of work that all of us need to do, I guess, in maybe advancing that clarity and holding international organizations accountable for their own human rights responsibilities. And each has to play their different role. Now, that said, we do need international organizations more than ever, and particularly the international human rights law system. And yet what we're seeing now is, again, the tip of the iceberg. There's been, I think, at least 20 years of erosion, for instance, of core budgets of different UN bodies. What that means is that UN agencies have lost the capacity to program, to develop a certain work, and rather be almost on a client-based relationship with funders. And we're now, so that already has changed some institutional culture. And now we're at a point where they don't even have a budget anymore, or we have such a smaller budget that many are looking at, if not closing down, but downsizing to a point where they might not be able to fulfill their mandate. And this, I think it's really important to understand that significant attack to our international human rights and other organizations in the context of a concomitant destruction of other support organizations. So the whole funding of official development assistance, the destruction of USAID last year, what it meant for all. We've also seen a global trend of national laws restricting the capacity of NGOs to receive international funding and other restrictions to their activities. So that means there has been a systematic destruction of all support, local, international solidarity, and international organizations for the human rights holders who are facing the brunt of climate change, and also all the advocates for phase out of fossil fuels. My reading of the situation is that is the very latest chapter of the textbook of climate disinformation and obstruction that we have plenty of evidence fossil fuel companies have written and applied. And again, it's really interesting to look at how the Inter-American Court has really looked deeply at these areas of climate disinformation and obstruction as harming our very democracies. I think we're all wondering what to do there, because it's also imagining a way to operate without all our usual sources of support, even if all the sources of support were not perfect, but they were there and they have played a role. And it really takes, I think, a lot of imagination, a lot of connecting. I think particularly thinking around the role of academic institutions and how we can work in solidarity with the UN at this point, and how we can work directly with human rights holders, defenders, and the organizations working with them who are also under attack and under-resourced, and all playing, I think, our role in protecting human rights, democracies, and advancing climate action. Because, yeah, this is how far we've gone with that obstruction.
Thanks. I'll take one more question, and I think there was one over here. Oh, okay. I think there's actually someone right behind you. So, yes? Okay, you're the last one. Thanks.
So you discussed a bit trying to narrow down problems to something more manageable can kind of prevent us from targeting the actual cause. And I'm just wondering what role you see lobbying in something like that, because I find a lot of the time lobbying governments, we end up having to lobby for things that are much smaller scale because they don't tend to address issues if they aren't smaller scale. So I'm just wondering where you see like addressing a root cause being lobbying.
So this to me connects to the area of transformation science. So we've, when I guess we started our work as international environmental lawyers, I think we're educated with the understanding incremental change will get us there. And that's why, narrowing down help us to work the incremental change. And I think now all global scientific assessments have indicated that we're not gonna solve the planetary. In fact, we're into multiple planetary crises because of that assumption, and we need transformation. Now, then, of course, governments like transformation. What does that look like, and how are we gonna do it? And there is still this idea that we're already trying to do something very hard, and everything else that you ask is gonna make that even more difficult. So when I have conversations on, well, climate action needs to be also human rights action, everyone is like, are you kidding me? I'm already trying to do something impossible, and I have to do something else. And I think the first step there is saying this is not something else. By bringing together those elements, you actually realize what you really need to do, that point about priorities. And you realize it's not about doing something different. It's about finding the action that addresses those multiple objectives. But the other thing I think is, of course, that's the beginning of how we realize that we need transformation. And how do we transform? Transformation comes from the bottom up, and that means that we need to develop pilots. And I think in my own work, and that was one of the, intuitions behind the One Ocean Hub, is that admittedly it's very hard for governments to be innovative and to pilot for all different reasons. But maybe that's where the research community comes in, and where we need to find fair alliances between researchers, human rights holders, civil society, and parts of government, and say, okay, let's try a pilot together. Let's see what that looks like, but also let's see how we all transform in doing that. And once we see some advancements and some learning, that's what we offer to government. So we don't ask them to change. We show them how change is done and how it happens in a way that's meaningful to us, protects our human rights, and here we have worked out. So it's co-developed as well, which again, for governments or UN processes, is very difficult to put together.
Well, that is a wonderful note to end this evening. I want to thank you very much, Professor Elisa Morgera, for joining us this evening and for such a wonderful talk. And I just also want to give a quick thanks to Laurie McDougall for supporting, and Emma Peckham, who's done a great job in supporting us this evening as well as others within the MILA community who've been very helpful. And finally, our dean, who is always a big supporter of our events. So thank you, Sarah Harding.
Yeah, thank you all for
So,